Good evening. This is the first Glasgow Advocate Talks podcast of 2026, and it's the response to the news today that the former Chief Executive of the Scottish National Party, Mr. Peter Murrrell, has been indicted for a preliminary hearing in the High Court of Justiciary in Glasgow on the 20th of February 2026. Now, I won't be saying anything at all about the circumstances of the case, but some news organisations have been in touch to ask what a preliminary hearing is, what happens at preliminary hearings, and what further procedure there might be following upon the preliminary hearing. So just a short video just explaining the answers to some of these issues in the hope that it aids an understanding of just exactly what's going on. To explain what a preliminary hearing is, it's probably easier to explain what the procedure was before preliminary hearings were invented, which was now about 10-11 years ago. So if we go pre-2015, the procedure was exactly the same in the sense that the accused would make the first appearance at Glasgow Sheriff Court. If he was granted bail, that would be an end of that stage. But often the accused would be remanded for 7-8 days and would then be fully committed at the end of that period, either remanded in custody at that stage or placed on bail. Now, that procedure hasn't really changed at all. What used to happen is that within a period, depending on whether the accused was in custody or in bail, it would be necessary for the Crown to serve an indictment. And pre-2015, that indictment would simply contain the date for the trial. But that turned out to be a pretty shambolic process, and certainly by the time I called to the bar in the year 2000, there were regularly 50, 60, sometimes 70 trials down for any 2-week sitting of the High Court in Glasgow, at a time when I think there were only 6 trial courts. And that would be a combination of the cases which had been cited for that particular sitting, together with all the cases which had been adjourned from previous sittings, of which there were many. It wasn't a particularly good system. Most people proceeded on the basis it was highly unlikely that any trial was going to start, and that sort of encouraged inefficiency. Somebody who did not encourage inefficiency was the Honourable Lord Bonamy, who I was very fond of, still am. He's retired now, and he was detailed, he was the obvious person to carry out a review into that procedure to see whether any better procedure might be instituted. And it was Lord Bonamy who recommended the introduction of preliminary hearings, and his recommendations were accepted, and the first preliminary hearing court sat round about 2015. Initially there were preliminary hearings in Glasgow and Edinburgh. More or less all the preliminary hearings happen in Glasgow now. It was thought best to centralise it and only have them in one place. There are about 6 preliminary hearing judges, so not every judge who sits in the High Court is asked to conduct preliminary hearings. It's a small sort of cohort of 6, and the idea is that they would have regular contact with each other and try and maintain a consistent approach. So that shows the difference between the old system and the new system, and now when you receive an indictment, there's no mention of any trial date. The date which is on the indictment, in this case the date that will be on Mr. Murrell's indictment, will be the 20th of February 2026. So What happens at the preliminary hearing? Well, I suppose the most significant thing that happens at the preliminary hearing is that the accused has to tender a plea. If the accused tenders a plea of guilty, then the case can theoretically be dealt with at that stage. In the case of someone like Mr. Murrrell, if he tendered a plea of guilty, they would need to get a background report in relation to him. But in the case of someone who has been in prison numerous times, where imprisonment is absolutely inevitable, it's not unusual for the plea to be tendered at the preliminary hearing and the judge simply to go straight into passing sentence at that stage. And that's an obvious benefit of the preliminary hearing system, that you get all the cases where a plea of guilty is tendered out the system early. Well, that was the plan. The case isn't never really indicted that early these days. The other thing which can happen at the preliminary hearing, of course, is that the accused can plead not guilty. And in that situation, the purpose in calling the preliminary hearing was to make sure that everybody was ready for trial. That probably sounds a bit self-evident, but the problem with the old system, when you just get an indictment with a trial date on it, which was only about 4 or 5 weeks hence, regularly counsel would turn up and say, well, we're not ready, we need to get an expert report, we need to trace this witness, that kind of thing. So the idea is that all the preparatory work is done by the time of the preliminary hearing. The Crown and Defence indicate at the preliminary hearing that there is that they're both ready for trial, and the idea should be that if a trial's then fixed, then unless something extraordinary happens, there should be no reason for the date of the trial to change. Obviously, people might not be ready for the preliminary hearing, quite often in big cases with lots of documents, lots of productions and lots of witnesses. Sometimes the defence hasn't had time to consider all of that, and in those circumstances the preliminary hearing can be postponed. Now, it's pretty unusual these days for the parties to turn up at a preliminary hearing and ask for the preliminary hearing to be postponed. By far the most common way for it to be done these days is that if the Crown and the Defence agree that more time is required before the preliminary hearing can actually call before a judge, a joint written application can be made by the Crown and the Defence asking for a new date, and that happens, I would say, in relation, if there are 12 preliminary hearings listed for any particular day, probably about 6 of them on average will be postponed that way, because obviously it's a waste of court time if everybody's just turning up to say we're not quite ready to tell you what the situation is and we want to come back in a month or two. And these days it's not uncommon for preliminary hearings to be postponed for about 2 months when they first call, which is the most likely time that people will be slightly behind in terms of preparation. So that could happen. There's no guarantee that Mr. Murrell's preliminary hearing will call on the 20th of February if there are reasons which require more time for consideration. Then, without anybody really being aware of it, the Crown and the Defence could make an application to postpone the hearing. Now, assuming that doesn't happen, if he attends on the 20th of February, or if the preliminary hearing is proceeding on the 20th of February, there are 2 ways that might happen. It might call in court in the traditional way, but these days it's far more common for preliminary hearings to be dealt with on a virtual basis over the WebEx platform. So during COVID, there were obviously difficulties with people gathering in courtrooms or any other place, and the Scottish Courts and Tribunal Service moved on very, very quickly to a system where things could be done by WebEx. So we were doing all the preliminary hearings during COVID by WebEx, and because it proved so efficient, And obviously it saves money because we're not bringing accused persons from prison, for example, and generally they're dealt with much more efficiently. So I don't know, I've got no inside knowledge, but it's probably slightly more likely that if the case proceeds to a preliminary hearing on the 20th of February 2026, that will be done by WebEx in Mr. Murrell's absence, with the lawyers and the judge on a WebEx link discussing what the next step is. I've got absolutely no information as to what way anybody is likely to plead, but as I say, if it was a plea of guilty, that would be recorded and probably the case would go off for about a month to enable a report to be prepared. If it was a plea of not guilty, then the court would require to appoint a trial. Time bars, my information is that the first appearance in relation to this case was on the 20th of March 2025, which would mean that there would have to be a trial by about the 20th of September 2026. It used to be a year, but it was extended under the emergency provisions in response to COVID. But that is pretty unusual. Very seldom are the time bars actually able to be observed. That's nobody's fault really, it's just more trials than there are courts to try the cases in. And I had a trial fixed in December 2025 for January 2027. So a delay of about a year between the preliminary hearing and the trial is not in any way uncommon. Obviously this is a case which has attracted a great deal of public interest, and no doubt Scottish Courts and Tribunal Service would want to fix an earlier trial if they could, but I don't know if that's possible, because the reason my case was fixed for January 2027 was because there already were trials in the diary every week up until then. So unless special arrangements have been made, it looks likely that if there is to be a trial in relation to the case, that trial could be a year or so after the preliminary hearing. So as I say, I've got absolutely no knowledge of the case. I wouldn't discuss it even if I did have knowledge. Clearly these are live proceedings, but there has been considerable interest in the fact that a preliminary hearing has been appointed, and so I thought it might be useful just to give a primer as to what a preliminary hearing is. I'm happy to answer any procedural questions arising from this discussion. I probably haven't been clear enough in previous videos. I can't answer any case specific questions. We're not allowed to take instructions from anybody other than solicitors generally, but in relation to general points which arise from discussions in these short videos, I'm more than happy to answer them in the comments, provided there's no question of the comments causing any prejudice to any live proceedings. Okay, that's almost 15 minutes. Thank you very much.